Ready, start. It appears that while the petitioner's father, mother and grandmother were arrested, the petitioner was evading his arrest and he was declared proclaimed offender. Full stop. The charge sheet was filed in the trial court against all the accused in July 2007. Full stop. The case proceeded to the stage of arguments on the order of charge before the additional sessions judge, full stop. It appears from the order dated 3rd September 2008 passed by the learned ASI the, that during the course of the proceedings, the prosecutrix informed the court that she had accepted a demand draft of Rs 3.75 lakhs as the final settlement for the expenses incurred by the family of the prosecutrix during the engagement ceremony. Full stop para. According to the petitioner, thereafter, in the month of October/November, 2008, the petitioner and the complainant again got in touch with each other through internet and telephonically and started talking to each other. Full stop. It is stated that both of them agreed to settle their disputes and the complainant agreed to the quashing of the FIR. Full stop. It is claimed that since the petitioner and the prosecutor have settled their disputes out of the court with the help of friends and relatives, no useful purpose will be served if the trial goes on. Full stop. The petitioner has enclosed as an Exhibit 3 to the petition an affidavit dated 31st January 2009 sworn to by the prosecutrix in which she states that her disputes with the petitioner have been resolved and that she has no objection if the FIR is quashed. Full stop. The petition is supported by an affidavit of the father of petitioner in his capacity as power attorney of the petitioner. Full stop. The special power of attorney executed by the petitioner in favor of his father on 3rd September or December 2008 while in London has been annexed with the petition. Full stop. This petition was filed on 10th February 2009. Full stop. A status report has been filed in which it is stated that the petitioner, who is the main accused in the case, could not be arrested as code. He continuously evaded his arrest despite being declared PO in the case by the court of law. Full stop. Unquote para. This court is unwilling to entertain the present petition at the instance of the person who has been declared as a PO by the criminal court and who continues to remain a fugitive from justice. Full stop. The petitioner is not willing to be physically present in the country and appear before the trial court and yet seeks the indulgence of quashing of the criminal proceedings. Full stop. The offence that he is accused of is a grave one, punishable under section 376 IPC. Full stop para. We have an interesting situation where the petitioner seeks to cash the order dated 21st August, 2004 and yet refuses to join the proceedings pending before the Metropolitan Magistrate, largely on the ground that he is now residing in USA and subject him to the criminal process in India would be an unfair burden as is evident from the raised earlier to the constitutional validity of the Passport Act and rejected by this court. Para. The petitioner also submits that he has not yet been served with the summons. Full stop. The petitioner's counsel has further submitted that the investigation in his case ought to be conducted by sending him a questionnaire and he should not be asked to join the investigation in India. Full stop. The acceptance of such a plea would give a premium to the petitioner accused who happens to travel abroad and it will thus be open to such an accused petitioner to misuse the process of law to make a mockery of the Indian judicial system by asking for such a special procedure totally opposed to the principles of the criminal jurisprudence. Stop.